And the next case is Northern County Mortgage Company versus James and Nancy Lane, case number 2025-5622, heard pursuant to an order of reference. And appearing for the plaintiff is Mr. Mario Jones, and apparently the defendants are not present. Bailiff, please call the case.
James Lane. Nancy Lane. James Lane and Nancy Lane. James and Nancy Lane. Your Honor, I've called the case. It doesn't appear that the Lanes are here.
Thank you. All right, you may proceed.
Thank you, Your Honor. I call the court's attention to the filing of the original summons, notice, list pendants, and complaint in the office of the Clerk of Court for Charleston County on and to the affidavits of service on the defendants James and Nancy Lane filed in the case. We've also filed our affidavit showing the defendants did not answer the complaint, are in default, and that the defendants are not in the military service of the United States, as contemplated under the Soldiers and Sailors Civil Relief Act. I am the attorney for the plaintiff in this action, Your Honor. The original records in my possession and an examination of the records in the office of the Clerk of Court for Charleston County show that the defendants gave a written promissory note on February 4th, 2003 to the plaintiff, Northern County Mortgage Company, in the principal sum of $109,000, together with interest thereon from date at the rate of 5% per annum, with principal and interest being payable in monthly installments of $875.45, beginning March 4th, 2003. Offer the original note in evidence.
The original note is received in evidence as Plaintiff's Exhibit 1. No objection.
Thank you. I also call the court's attention to the provisions of the note with reference to default. I also call the court's attention to the provisions in the note with reference to payment of costs and attorney's fees.
So noted.
On the same date, James and Nancy Lane gave a written mortgage to Northern County Mortgage Corporation, and that mortgage contains the same terms and provisions as the note just offered in evidence, and conveyed by way of mortgage the identical property described in the complaint in this action, which is located in Charleston County, South Carolina. The mortgage was recorded in the office of the Charleston County Register of Deeds in Mortgage Book 2355 at page 267. This mortgage constitutes a purchase money first lien covering the defendant's property. I offer the original mortgage as evidence.
The mortgage is received in evidence as Plaintiff's Exhibit 2.
Thank you, Your Honor. We have examined the public records, and it appeared that no one other than the parties to this action have any liens or claims against this property as of the date of filing the notice of pendency of this action. We are presenting an affidavit stating the monthly installments as provided for in the note and mortgage were not paid in accordance with the terms and conditions thereof, and therefore the note and mortgage are in default. And as a result thereof, the plaintiff has elected to declare the entire unpaid amount immediately due and payable. Demand for payment was made on the defendants, but payment has not been received. The plaintiff has attempted to resolve the past due amount, but the defendants have chosen not to enter into any modification, negotiation, or other settlement. Pursuant to this affidavit, there is due and owing on the plaintiff's note and mortgage as of this date the principal sum of $86,950.34, together with interest thereon at the rate of 5% per annum as of January 5th, 2021, amounting to $4,092.88, plus other fees and costs shown on the statement provided to the court, including an escrow advance of $2,963.45, and title exam of $395. An appraisal fee and late charges, making the total due plaintiff in the amount of $94,401.67, plus cost of collection and attorney fees as provided by the note and mortgage. Costs that have been incurred in the litigation of this case are in the amount of $821.53. And that attached affidavit I mentioned says that in view of the potential liabilities inherent in a real property matter, the attendant responsibilities, and the size of the mortgage debt, I think that a reasonable attorney's fee would be $3,500. My law firm was engaged by the plaintiff to foreclose the mortgage as expeditiously as possible, given the detriment to plaintiff's equity position as a direct result of increasing losses from the running of interest. Plaintiff must also comply with investor requirements, government or private insuring agreements. Upon receipt of the case file, the title was examined to identify all parties having or claiming any interest in subject to the real estate. The following list of pleadings and other documents have been prepared or reviewed in this action: lis pendens, summons and complaint, required affidavits, affidavit of default, order of reference, notices of hearing, transcript of testimony, proposed master's report and judgment of foreclosure and sale, and notice of sale. Additionally, the pleadings were drafted and served upon each defendant personally. Reinstatement and payoff figures and payment histories were provided as requested or required. We scheduled and attended the hearing in this matter. Future duties include forwarding copies of the judgment to the defendants, obtaining bidding instructions from plaintiff or its designee, representing plaintiff at the sale or arranging for such representation, preparing an order of sale or report on sale, and disbursements and order confirming sale, and preparing the master's deed and any other documents necessary to this particular action. In addition to the time expended to date in prosecution of this action, we anticipate a minimum additional 4 hours after the hearing. Moreover, depending upon the interest shown by defendants, third parties, or counsel for either, and the inherent negotiations required thereby, other time may also be committed to the completion of the case. So I would reserve the right to revisit the question of attorney fees should the action proceed in an unexpected way. In regard to the professional standing of counsel, representation of the plaintiff has been undertaken by the firm of McCormick & Jones. I have been the attorney primarily involved in this representation. I concentrate my practice in the areas of foreclosure, bankruptcy, and real estate. Furthermore, this fee is in line with the fee customarily charged by counsel with similar experience in this particular locality. Also, the plaintiff's attorneys have achieved the beneficial result of a prompt foreclosure of the mortgage. The plaintiff specifically waived any right to a personal or deficiency judgment. There are no paving or other special assessments against the subject property. Taxes have been paid through 2021. We would ask that the mortgage be foreclosed, that the property be sold at public auction in accordance with law, that the sale be made subject to any liens for taxes and any special assessments of record against such property, also subject to payment by the purchaser of interest on the balance of the bid from the date of sale to date of compliance with the bid, also subject to any existing easements or restrictions of record, and also subject to payment by the purchaser for preparation of the deed and deed stamps.
Anything further from the plaintiff?
No, Your Honor.
Based on the documents and affidavits which you have presented, I find that plaintiff is entitled to a judgment of foreclosure. You have previously submitted a proposed order of foreclosure and sale, which I will sign and forward to the clerk's office, and the case will be placed on the next sale date. Anything further?
No, Your Honor.
That concludes the matter. Thank you.
Thank you, Your Honor.